Good evening, all of you. I think we are live. Hello, everyone. Good evening. Let's wait for 1 or 2 minutes and then we can start. Meanwhile, you can also tell me, I think the lighting is better today. Are you able to see the board? You can hear my voice properly. So you can just let me know. Board पे जो लिखा है, whatever is written, is it clearly visible? The small letters and the big letters? I think many of you say that it is visible. Not even the bigger letters? Alright. So I think this is the best feedback. It's visible, but the little ones are quite blurred. So do not worry about the little ones. This is just for the purpose of revision sake. I'll be, saying it to you, and you can just write it down in your pointers. You can make some points out of here. And then bigger ones are visible. I'll try to write bigger letters so that it's visible to you. So, and then tomorrow again, I'll try to resolve out. Every day, even I'm learning with you people. So every day it's a new learning for me. So I'll try to resolve this issue now tomorrow. Alright. So be patient with me, people. You have been really very patient with us. So be patient with me, be patient with RostrumLegal, and whatever feedback you provide, we will try to just work upon it. So let's see. शायद कल आपको ये दिक्कत ना हो. Alright, I have noted all your points, so I'll try to work upon it. So let's begin with the lecture, and फिलहाल अभी कोशिश करते हैं इससे adjust करने की, and I'll try to write it down again. Whatever I'll be doing new with you. ठीक है. So Welcome all of you at RostrumLegal. All right, and a very, very good evening, and thank you for being so patient. Right, you have been such a patient listener and learner as well. So let's begin. So yesterday we started with the topic negligence. Okay, हमने negligence की शुरुआत की है, and we will try to finish it as far as possible. Okay, before proceeding ahead, I just wanted to say that in negligence, there is a topic of professional negligence. Generally, exams में mains के point of view से there are no questions. As such, बहुत ज़्यादा it's not asked as far as mains are concerned. But in preliminary, they might ask you question related to Bolam test and all. So what I have thought for you is that see, negligence is a very big chapter, and it's actually not possible to finish it in 2 hours class for 2 days. Like 4 hours class, I cannot finish negligence with you. There are so many cases and all. So I have decided to make a video on professional negligence. I'll try to include even the recent judgments into it. So you can just go to the video. The links will be provided to you, and then you can have it at your disposal, and you can learn from there. So that is what I have thought about it. So let's see how much I can do, and I would need your cooperation in that. Or you need to tell me in the comment section that whether you find it useful or not. First thing. Second thing, I'll try to revise what we did yesterday, and then whatever possible, I'll try to finish off this topic, jitna ho sake. All right. So let's begin. Fine. So shuru karte hain. So we talked about that what is negligence. In simple terms, negligence का क्या मतलब है? Negligence means that there is a lack of duty of care. All right, because you being a reasonable man, there is a particular standard which is expected from you in a society to behave in a way, to conduct yourself in a way that your conduct does not cause any injury to someone else, as well as you protect yourself. But then if your conduct shows that there is some lack of care on your part, which was as a duty provided to you being a member of the society, so then that means that there is a negligent conduct, and this lack of care or due care and caution is called as negligence. I'm not giving you any definition which is written in the books. That you can very well find out from any book, any source, and you can just sit down and mug up. So try to make your own definition after you have understood the definition of concept of negligence. Then we also talked about that negligence is understood in two ways. So there are two approaches and two theories basically to understand the concept of negligence. Now what are those theories? Number one is the subjective theory that I have written over here, subjective, all right. And number two is the objective theory. Okay? Clear? All right. So what is a subjective theory? A subjective theory is a theory which considers negligence as a state of mind. So negligence is a mental state, that is a state of carelessness. That means an attitude of indifference. Indifference towards what? Indifference towards your conduct and the consequences of your conduct. Clear? Yahan tak? So it is indifference towards the conduct or the consequences of the conduct. All right? So ये है subjective theory. Why the liability arises? Here, people. Can you see? All right, I think it's blurred. कोई बात नहीं, try to listen to me, then I'll write bigger words. All right. फिलहाल अभी आप मुझे सुनने की कोशिश कीजिए. So there are two approaches which are being provided. One is subjective, one is objective. Subjective says that negligence is a state of mind, a mental state of carelessness, an attitude of indifference where there is indifference towards one's conduct and the consequences of the conduct. ठीक है? Clear? Fine. So why the liability arises? The liability arises because the person does not have the desire to prevent the harmful consequences of the conduct. So the person is completely indifferent, and it does not matters to him. The person does not bothers at all that what will be the consequence. This is subjective theory, which talks negligence as a mental state. Okay, and it has been provided by Salmon, and it has been it has been supported by Winfield. All right. Now, what is objective theory? Objective theory of negligence, which is considered to be a more practical approach of negligence, it says that negligence is not a mental state. Rather, negligence is a kind of conduct. So, objective theory क्या बताता है कि negligence is not a mental state. Rather, negligence is a kind of conduct. And what is the justification being provided? The justification being provided by Pollock who is the propounder of this theory, objective theory. He says that negligence is opposite of diligence. And nobody considers diligence as a mental state because diligence is something that has to be seen in your conduct. All right. So same is the case of negligence, that whenever a person does not conduct himself or herself with due care and caution, which is the duty of the particular person, then we say that the person has performed negligently. So this objective theory is considered to be a more practical approach, in comparison to the subjective theory. Clear? अब आगे चलते हैं. Alright. Now, उसके बाद we discussed that what are the elements of negligence. Elements of negligence कहने का मतलब that if there has to be an action for negligence, if the cause of action has arose, something has happened, if there has to be an action for negligence, then in that particular case, the plaintiff has to prove certain elements against the tortfeasors. Clear? Now, what are these elements? So, these are three elements which the plaintiff has to prove against the tortfeasor if the action for negligence has to arise. Right? Number one is that the plaintiff has to prove that the defendant owes a duty of care towards the plaintiff. See, if you are not able to see the board, all right, so I request you that please, write it down because we have already done this thing yesterday at length. I'm just repeating things. So if somebody is joining new today, if somebody has not attended yesterday's class, so you can just, go back to the previous video and watch it because I really want to proceed ahead. Fine. So coming back to the topic, what I suggest is that negligence, in order to arise an action in negligence, there are three elements that has to be proven by the plaintiff. What are those three elements? Number one, that the defendant owed a duty of care towards the plaintiff. ठीक है? ये पहली चीज है which has to be proved. Now, when we were discussing about a duty of care towards the plaintiff, then we tried to understand that duty is not just any duty. We are talking about a legal duty. So we are not referring to any social, moral or religious duty. Remember, this we have already done in the first class in the first chapter. Okay? When we were talking about legal rights. So a legal right will have a corresponding legal duty. है कि नहीं? Yes or no, right? So that is how we have to understand that when we are saying that the defendant owes a duty of care towards the plaintiff, so this duty is a legal duty and not just moral, social or religious duty. First thing. Second thing, that और इसमें legal duty में remember what is the case that we discussed? What is the case that we discussed in legal duty? Anybody? What is the case we discussed in legal duty? याद है किसी को? I am waiting for your answer. Very good. Kevin versus Fender, and very good. Tunnock versus Stevenson. Okay? That ginger beer bottle case. That ginger beer bottle case. Absolutely. So everybody has got it right. So in this legal duty, we have understood that we have talked about that there are two cases, Heaven versus Fender and Tunnock versus Stevenson. Now, what is the difference between Heaven versus Fender and Tunnock versus Stevenson? Can anyone tell me? I've already explained it to you yesterday. Can anyone tell me what is the difference between Heaven versus Fender and Tunnock versus Stevenson? Anyone? Absolutely. 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 I'm so happy to see the correct answers. Absolutely. Thumbs up to all of you. All right. Well done. So, Heaven versus Fender is about that when you talk of that a person's liability or duty arises towards person and property as well, not just people. So, a person's liability arises towards, people or property who are in the proximity, who are in the close proximity of the person, that respective person or the defendant. But in Tunnock versus Stevenson, who is my neighbor, this concept was expanded, and the concept of liability towards my neighbor was also expanded. Because what were the two defenses taken in Tunnock versus, the facts, so I'm not getting into it. We have done at length yesterday, right? So what were the two defenses which was taken by the defendant? One, that I don't owe any duty of care, and second, that Tunnock is stranger to contract. All right. So these were the two defenses which were taken by the defendant. That number one, that there is no duty of care of defendant towards the plaintiff appellant in this particular case. And secondly, what was the another defense that was taken by the defendant? That Tunnock is stranger to contract because my contract was with the retailer and not with particular law. So what did the court say? The court said that first of all, the manufacturer's logic, the reasoning or the obiter dicta which was maintained by the court. The court said in this particular case that if a manufacturer produces a product in a way that you intend to make that product reach to your consumer in a particular way, and there are no chances of intermediate inspection or intervention that may lead to ratify any mistake or rectify any mistake, then in that particular case, the manufacturer's liability arises. And secondly, in tort, the concept of or the maxim of love thy neighbor gets converted into is actually to not hurt your neighbor. And then another question which arises, who is my neighbor? So any person who is getting directly affected by my conduct is my neighbor. So it does not matter that whether that person, was in my physical proximity or not, or whether I had any contract with that particular person or not. All right. So in tort, there is no privity of contract. Fine. Now, why so? Because I tried, this has been explained as the basis of difference between contract and tort, because we know that in contract, the rights are right in persona, but in tort, the rights are right in rem. So this is the difference in the nature of the right in the law of contract and law of tort. All right. तो यहाँ तक हमने कर लिया था कल. अब थोड़ा आगे चलते हैं. Fine. Let's move forward. ठीक है. So is legal duty enough? अभी हम लोग पहले पॉइंट पे ही हैं. So the defendant needs to owe a legal duty or duty of care towards the plaintiffs. So is like having only legal duty enough, or we need something else? What is that something extra that we need to give rise to the cause of action? What is it? Is legal duty enough? Or we need any other thing as well? You forgot? I'm not coming to the point of breach of legal duty. See, the reasonable foreseeability of the injury, how can you forget that? Alright? So the reasonable foreseeability of the injury is also necessary. Just having legal duty is not enough. So besides legal duty, number one, you need to have the reasonable foreseeability. Remember, we discussed who is a reasonable man. And secondly, there should be the likelihood of the injury as well. Fine. So reasonable foreseeability of the injury is very important in order to understand that whether there was actually, any duty of care towards the plaintiff or not. Now, in reasonable foreseeability, I discussed with you yesterday, but I haven't provided any case with you. Did I give you the case of Rural Transport Service versus Bejlam BV? I don't think we discussed this case. Did we discuss this case yesterday? Rural Transport Service versus Bejlam BV? All right. So I will tell you, just write the name, I'm just erasing this off. Rural transport. So we are discussing about reasonable foreseeability. So can you see this now? This word rural. All right. ये दिख रहा है मेरे ध्यान से शायद, right? All right. So Rural Transport Service versus Bejlam BV. Calcutta High Court का केस है ये. It's visible, right? ठीक है. So, in this particular case, what happened? That there was this overloaded bus, all right? So the conductor of an overloaded bus, try to understand the facts, please. So the conductor of an overloaded bus, he just invited passengers to travel on the rooftop of the bus. The top of the bus, आपने देखा होगा बहुत बार लोग बस पे बैठ के जाते हैं, and the bus was completely overloaded. Okay, it was full packed. Now what happened that one of the person, like there were many people, like one of the person who just climbed on the rooftop of the bus. So there was this, when a turn came and there were trees on the highways and there was this branches hanging. So one of them Halaki, many of them got injured. So one of the passengers just fell down when the bus driver swerved the bus in the right direction. So what happened? That one of the passengers who was sitting on the rooftop of the bus, he fell down and he died. Right? He was severely injured and he was brought there. Now, in that particular case, the wife of the deceased, the widow, she's claiming she has alleged tortious liability against the bus driver and the conductor, and then she seeks compensation in this particular case. So in this particular case, it was held by the court. No, what was the defense taken by them? The defense taken by them was that we cannot see this coming. That this person can die because it is a regular routine. Many people sit on the rooftop of the bus. So आज भी होता है. ये 1980 का case है. हम आज भी देखते हैं. Still we witness such incidents happening around. All right. So the court said in this particular case that there is a complete, foreseeability and the foreseeability of a reasonable man, and also the likelihood of the injury in this particular case, that if you are in an overloaded bus, if you are asking someone to come and sit on the rooftop of the bus, so there is a special duty. First of all, you should not invite that passenger to come and sit on the top of the bus. It's already overloaded. Secondly, if you have at least invited somebody to sit on the top of the bus, then it's the duty of the driver to drive the bus in such a way so that nobody gets hurt. So when the driver was basically swerving the vehicle, so there was an added responsibility on the part of the driver to take some extra care. Remember, we talked about magnitude of risk also. So these are all, overlapping, intermixed, intertwined. You cannot just separate them and you can just analyze the concept. You have to bring in all the concepts together and just analyze a particular case. Fine. So that is what the beauty of tort is. So the court said that this is a clear case of defying the reasonable foreseeability that was there, because it can be foreseen that if you are performing such conduct, then there will be certain injury which is caused. All right. But this case of Rural Transport Service versus Bejalam BV will be doing, since I haven't done cases with you, so that is why I started from here. So this case of Rural Transport Service is also discussed in case of contributory negligence. Don't you think it's a case of contributory negligence, people? Yes or no? Is it a case of contributory negligence? Is it a case of contributory negligence? Do you think so? When you know that the bus is already overcrowded. Now here only we will discuss the concept of contributory negligence, which is one of the defense of negligence. मैं बताऊंगी अलग से, but just to give you an example. Now, what is contributory negligence? If we break the word, what is contributory negligence? That you have contributed into the negligence. If you would have not contributed as far as your action is concerned into the negligence, then the consequence would not have occurred. You're getting my point? So you have contributed by your conduct into the happening of that consequence. So that is why there is a concept of contributory negligence. So don't you think that this case of Rural Transport Service versus Bejalam BV should be discussed in contributory negligence also? Yes, definitely that is an example. But then tort is full of so many cases. So if you have understood the concept, the basics, you can, apply your mind, you can apply your judicial mind and you can decide upon the facts of the case. Even if you don't I guarantee you my words, you can just write it down anywhere. Even if you don't remember the name of the case on the spot, all right, but you can analyze the facts of the case, and even if you write X versus Y, and you can just recollect that there was such and such case where it was held, but it's better to not write a wrong name rather than writing, not writing the name at all. So still your purpose is solved and you get evaluated and you get good marks in that. So this is what you have to consider in reasonable foreseeability. All right. In likelihood of injury, we have already discussed one case yesterday. Besides, I have to provide you certain cases which I'll be providing you, along with either you will find in your test that will be happening, because it was suggested to be happen on Saturday, but I don't think that I'll be able to finish it off by Saturday. I might take an extra day, people, so get ready for it. And your test might happen on Sunday. So let's see what we can do. All right. Now, in this foreseeability only, there is another case of, please write it down, Sushma Mitra versus MP State Road Transport Corporation. All right. I'll just read this off. Sushma Mitra versus MP State Road Transport Corporation. आप ये full form लिख लीजिएगा. I'm not writing it in full form. This is MP State Road Transport. Can you see this? So Sushma Mitra versus MP State Road Transport Corporation. So what happened in this particular case, so there was this plaintiff who was actually resting her elbow on the windowsill. It's a very natural practice we still do today. If you have traveled by bus, or if you travel by, or even car for that matter, train maybe we want, even flights we want that window seat. So that's a very natural instinct that we do, that she was resting her elbow on the windowsill, and one truck, it was coming from the opposite side and just hit her on her elbow and she got injured. All right. And then she sought after compensation in this particular case, where they said that there is no liability as such. Where is my liability? I don't have any duty of care. There was the foreseeability. So there was a likelihood. So in this particular case, the court held that basically just they provide you, I'm going fast because they'll ask you the name of the case and then they'll ask that it's related to which concept. So in this particular case, the court held that in the highways, when there are vehicles who are running adjacent to each other, so it's the duty of the vehicle or the driver of the bus or the truck to maintain a proper distance. So if you're not maintaining a proper distance, because there is a reasonable foreseeability, if you're running at a very close distance, so you might cause some injury to the person. So that is why it is necessary to maintain a proper distance while you are traveling on the way. Right? So that is how the liability arises. So let's move forward. So you have written down the case, Sushma Mitra versus MP State Road Transport Corporation. All right. Now let's talk about breach of duty. So what is breach of duty? So this was the first point that I mentioned, that has to be a duty of care. The defendant owes a duty of care towards the plaintiff, so the plaintiff has to prove this. What is the second point the plaintiff needs to prove? That there has been breach of duty. Now what is this breach of duty? That there was the requirement of due care and skill to be exercised to conduct yourself, and you have not done so. You have been negligent in conducting yourself. So that is why there is a breach of duty. And while explaining breach of duty to you, I mentioned that we also have to take into consideration the magnitude of the risk involved, because the amount of due care and skills required in a particular situation may change from situation to situation. So that is how we analyze that what was the duty of care and skill required in a particular situation depending upon the facts and circumstances of each case, and whose standard we follow while analyzing it, the standard of a reasonable man. All right. So let's move forward. What is the next point? Now, this breach of duty must lead to some damage. Okay? So there has to have some injury, some damage caused to the person. Now, in some books, you might find the word injury. In some books, you might find the word damage. There is nothing wrong into it. People just don't get into so much of jargons. All right, till the time you are like writing, like any of the book which you can refer, so you can say it as injury, you can say it as damage. It is completely your wish, because it's not that these are not my words. These are the words which are written in the books in itself. So that is why the breach of duty when leading to damage, so we have this concept of remoteness of damage. So we cannot question them that why didn't you write, remoteness of injury. All right. If you want to, that's an area of research. We can do that, but I think this is not the right time. All right. So when we talk of damage, first thing that the defendant owed a duty of care towards the plaintiff, but there has been the breach of this duty, and this breach of duty has led to what? Has led to some sort of damage or the other. Okay. But the defendant cannot be made liable for each and every damage. That is what we have to understand. The defendant can be, okay, I'll get back to you, Farhana. Okay. The defendant can be made liable for only those consequences of the damage, or only those consequences from the conduct of the defendant which are actually the probable cause and not a very remote cause. So what is this concept of remoteness of damage? Is it visible, people? All right. So what is this concept of remoteness of damage basically? So this remoteness of damage, it basically acts as a limitation to an action for negligence. ये आपको मैंने कल भी बताया था. All right. That what does this remoteness of damage does? It acts as a limitation. So I'll just write it down. So if you just want to use this statement. Because we talked about it yesterday that we have to differentiate between limitation to an action for negligence. You understand, right? So it is kind of an immunity, or it is kind of a defense which can be taken by the defendant, which actually restricts his liability. So a person cannot be made liable ad infinitum, right? A person cannot be made liable. So the carelessness, as I said yesterday, it cannot be in abstract. So there has to have some rules, some theories to limit the liability of the persons. That is how we need to understand. So there are we talked about that. What is the difference between causa causans and causa sine qua non. Please write this maxim as well. In jure non remota, right? If you are able to see, in jure, they might ask you, non remota, alright? Can you see this? In jure non remota, causa sed proxima spectatur. Causa sed proxima spectatur. Proxima spectatur. So in jure non remota, causa sed proxima spectatur. What does this mean? It means that what is to be considered in law is the immediate and the proximate cause and not the remote ones. So if you can start and if you can remember this maxim, you can use it in your mains if you are writing, answer on remoteness of damage. And they might ask you this maxim in preliminary and will provide you with options that it is related to what, or this case is related to this maxim or not, something like that. Fine. So in jure non remota, causa sed proxima spectatur means that what is to be considered in law is the proximate and the immediate cause and not the remote cause. So a person can be made responsible. People, if you are writing it down, please write it down or you can repeat the video and see. So a person can be made responsible only for the intended consequences or the probable consequences and not a consequence which is so remote that it cannot even be thought for that this can happen. Alright? Clear? Alright? It's spectatur. Alright? Now, there are two theories which talks about, so we have discussed the difference between that causa causans. Remember I gave you that example of 1857 का revolt and then that axe wala example, causa causans and causa sine qua non. Causa sine qua non. I hope you have written this down. If you are writing along with me, limitation to an action for negligence. And one thing more I wanted to ask, do you want me to go fast? Like I'm purposely going slow so that I can make you understand. This is not clearly visible. Should I this is not clearly visible. Should I write it down? नीचे यहाँ पे? You want me to write it down again? I think I asked you the wrong question because there's going to be a file in your chat group. Because some people want it to be faster and some people want it to be at the current pace. Like I have just tried to reduce my pace because yesterday few of you were having problems, but then I think I need to decide on my own. I cannot leave it on you. Fine. So I repeat, if you can just, it's in jure non remota causa sed proxima spectatur. Okay? Now, why there is this question on why do we need to differentiate between causa causans and causa sine qua non? What is causa causans? I told you that causa causans is the immediate cause, most effective cause. All right, most effective cause, the real cause. So that is why we need to differentiate. Alright. So causal is the immediate cause, the most effective cause, and the real cause. Remember in that axe story, what was the immediate cause? The pushing of that boy. Alright. So that was the causa causans. If the boy was not pushed, he wouldn't have fallen on the axe and he wouldn't have got injured. So that was causa causans. What is causa sine qua non? Causa sine qua non is a cause sine qua non, a cause without which the action would not have started. So that is causa sine qua non. So what was causa sine qua non in that example? The leaving of the axe by the woodcutter. Okay? Clear hai? So that is why we need to differentiate between the two, because if we will not understand that what is the immediate cause and what is the what is the causa sine qua non, that the real cause, then you have to there has to be some limitation drawn upon for the defendant's liability. Just because something has happened, you cannot make the person liable for everything under the sun. Okay, so this does not mean that just because a plaintiff goes to the court and the aggrieved party goes to the court, so the entire judicial proceeding or the judgment or the idea of justice has to be only in the favor of plaintiff and not in the favor of defendant. You have to understand one thing. Being a plaintiff is one thing and being a decree holder is another thing. They are not just one and the same thing, people. So get this very clear in your mind. Okay? So kahin na kahin you have to draw the limitation. So that is why we have two theories. Earlier there were two theories. Still we discuss about them. Halaki, the theory of probabilities sustains now. So what were those two theories? The two theories was theory of direct test of directness, alright, and then the other theory was the reasonable foreseeability or the जिसे हम test of probability भी कहते हैं. I'll write it down. I'm just erasing this. Hope you have written it. So what were those two theories, right? And we stop here. Can you see this? Test of directness and reasonable foreseeability. Alright? Or you can call it reasonable foresight, or it is also known as probability test. We can give you this name and ask. Probability test. We generally ask what are the two theories, basically, and the cases related to them. They just have the name, or they'll say that which are these cases related to test of directness, which is what was held in this particular case. So, मैं बताऊंगी अभी आपको, we'll be talking about it. Okay? So there were two theories related to remoteness of damage. Number one, test of directness. Number two, reasonable foreseeability or reasonable foresight or probability test. Now, what is this probability? Notice this. I'll first come to test of directness or the test of direct consequences, that a person is responsible for all the direct consequences of his or her act. Okay? That whatever are the consequences of a person's act, the person is responsible for this those particular act. Now, what is the case related to it? So please note down, the case is Smith versus London and South Western Railway Company case. Wait, I'll write it down. Smith versus London and South Western Railway Company case. I think this is a case of 1870. Let me check. This case is related to test of direct consequences. Alright? Test of direct consequences. Or test of directness. Now, what happened in this particular case in Smith versus London and South Western Railway Company case? Now, this is the first case in which this test was upheld. If you want to write down, you can write down. They might ask you, right? And there has been questions on this case. So, if you see the question banks, you will find it over there. So, this is the first case in this test of directness was applied. All right. Now, what happened in this particular case? These railway, these people who are working in the railway company, right? What they did that that there is this, grasses around these railway tracks. So what they did, the people who work for this railway company, they, after cutting those grasses, they actually, they just left those heap of grasses around the railway tracks, and they just went away. Now, what happened that rail, when the rail passes through the tracks, so that there are these engine sparks which are created. So one of the on one day, these engine sparks, they actually, the heaps, the grasses which were lying over there, so it caught fire. And this fire, because wind was blowing, so this fire actually got spreaded to almost, I guess, 200 yards, quite a few kilometers, and it actually damaged the cottage of the plaintiff. So, and it actually spread it quite far apart. So the court, held, so there was this defense taken that it was not there is no reason to punish us, or the liability does not arise because we did not see over there that the fire will spread with the help of wind, and the cottages will get caught in under the fire, and there will be damages which will be caused. But then in this particular case, the court held that a person is liable for all the direct consequences of the act. So it cannot be said that this was something which cannot be foreseen. All right. But then later on, this test of direct consequences were considered to be quite harsh, and later on it was realized that this is not an appropriate test in law, and it was held that this is not a good law to actually make a person liable for everything or whatever the consequences are of a particular conduct. So that is why this test of reasonable foreseeability came. Now, before going to the reasonable foresight test or the probability test, alright, one more case where the test of directness was discussed is the case of Remoteness case. It's a very famous case. You just write down the name, right? Remoteness and Furnace with the and company or Whiteley and Company. Yes, we pronounce karna chahe aap. Remoteness case. It's famously known as Remoteness case. Remoteness. पूरा नाम लिख दो. Remoteness and Furnace. Alright, so the test of directness, whatever was held in the case of Smith versus London South Western Railway Company case, was also held in applied, and that principle was applied in Remoteness and Furnace and Company case. Alright. Should I tell you the facts of this case? Thoda sa, I'll just read it out to you in case if you don't want to go into the detail. So what happened in this case, the defendants basically, I'll go very slow so that you can, because it's thoda sa tricky hai, the facts of this particular case. So what happened in this case? The defendants, they chartered a ship. All right. Now the cargo basically to be carried by them, it included a quantity of some kind of petrol and benzene, and there was this leakage in those tins, and some of the contents were like actually collected in the hold of the ship, जो नीचे का area होता है. So basically the defendants, they were carrying benzene and petrol, and there was leakage in the tin, in the canister in which they were carrying this benzene and petrol, and some of the material, it got collected into the holds of the ship. And then after that, what happened? That no, and it was because of the negligence of the servant of the defendants. Basically, this thing happened. Now, the servant, the defendant servant, he actually, because of his negligence, a plank, wooden plank, right? So, a plank, it fell over there into the hole, and a spark was caused. All right, where the material of the benzene and the petrol, that these are like flammable material, and it can catch fire very easily. So a plank was thrown over there, and then what happened? A spark was caused, and consequently the ship was totally destroyed by fire. So this happened. Now it was held, particularly in this particular case, that the defendants were liable for all the direct consequences of their servants' negligence, and including the destruction of the ship, even though the consequences could not have been reasonably foreseen. Now, this was not something which could have been reasonably foreseen. It was taken as a plea that there will be leakage, and there will be then after the leakage, the benzene and the petrol will get collected into the hold of the ship, and then a plank will fall into the ship because of some negligence of the servant, and there will be spark, and the ship will catch fire. So this was not under their idea at all, or thought process at all. But then the court in this particular case said that once the negligence is established, once that it has been established in the court of law that the conduct of the defendant is negligent, then whatever is the direct consequence of the negligence, the defendant is liable for that. Clear? बस इतना ही है इसमें. You have to understand only this much. Don't try to get, if you want to read this on your own, you can do it, all right? But then, as far as your examination point of view is concerned, this was more than enough. That there was a ship, the defendant chartered a ship, and there was this leakage in the tin of the benzene and petrol, and they got collected into the hold of the ship. The plank fell into the hole because of the negligence of the servant, and a spark was caused which led to the fire into the ship, and the entire ship destroyed. Now, since it was a chartered ship, so the defendants were held liable for the destruction of the ship. That is the consequences of their conduct, even if it was not foreseen. Clear? It's not clear? The facts are not clear? All right. So, in this real polymer's case, what happened? That a defendant chartered ship. समझते हैं? ठीक है? You people understand? All right. So, ship was basically chartered. किराए पे लेना. So, basically, it was chartered for the purpose of cargo. All right. So, cargo carry करने के लिए, goods carry करने के लिए, the ships were chartered. Now, that ship was carrying the tins of benzene and petrol. Now, there was some leakage in the tins, in the canisters. Now, what happened? And because of the leakage, some of the contents of the tin, it got collected into the holes of the ship. All right, the below surface of the ships. Now, what happened? That because of the negligence of the defendant servant, the plank, one of a plank, it fell into the particular material, the hole, and it caused fire. There was a spark, and fire was caused, and it destroyed the entire ship. And after that, they were made liable. The defendants were, since it was a chartered ship, so the defendants were held liable for the entire destruction of the ship, even after taking this plea, that this damage was not within their foresight. They did not have seen this coming, that there can be such kind of leakage and spark, and the destruction can happen. Because what did the court say in this particular case? Because they give you the sentence and they ask that once a negligence has been established, then a person, ये negligence तो establish हो गया कि leakage था, right? Leakage अगर था इनमें तो कहीं ना कहीं आपका negligence था, all right? So once a negligence has been established, then what is there? It has to be taken in this way that a person is liable for all the direct consequences of that negligent conduct. बस अब दोबारा अब आप वीडियो एक बार और देख लीजिएगा. All right. Now let's move further, people. Now there is this another case of. Now let's talk about the test of reasonable foresight. Clear? Now what is this test of reasonable foresight? Test of reasonable foresight is also known as test of probability. Now, what is this test of probability? As I earlier told you, that a person can be only made liable for the probable consequences of his or her conduct. A person cannot be made liable, for each and every of the direct consequences of the conduct, but rather which are the probable. There is a probability that such consequences can happen. So, a person can be made liable only for those conduct. All right. So there's this very famous case of wagon mount case. Famously, it is known as wagon mount case. However, the complete name of the case is, now let me write it down for you. This is Overseas Tank Ship UK Limited. Overseas Tank Ship Limited versus Mott's Dock and Engineering Company Limited. Mott's Dock and Engineering Company Limited, and this case is famously known as wagon mount case. दिख रहा है? Can you see this, people? Overseas Tank Ship UK Limited versus Mott's Dock and Engineering Company Limited, famously known as wagon mount case. It's a case of 1961. All right. Please write down the name of the state, because this is what they ask you in the exam. Okay. Now, very patiently, you have to listen to the facts of this case, because the facts of this particular case and the re-polymus case are more or less similar. It's just that in wagon mount case, they mention a bunkering operation. You understand what is bunkering operation? People, what is bunkering? Anybody can tell me? What is bunkering operation? . 。 Just remember the word bunkering operation, then you will be able to differentiate these two cases. That is the trick to remember this case. Anybody? Try, at least give it a try. What is bunkering operation? See, bunkering is, how many of you have, बहुत सारे movies में you must have seen, how many of you have seen Air Force One? There's so many movies. You don't have to go to Air Force One if that's such a old movie. Oldest movie, one of the oldest movie I've seen, but then yes. So I just recall that there's a scene of, oil refueling. So bunkering means oil refueling, any fuel for that matter, the filling of that fuel in a vehicle or no conveyance, the mode of conveyance. So that is bunkering operation. All right. All right. Great. So what happened in this particular case? Remember, Overseas Stampship UK Limited versus Mott's Dock and Engineering Company Limited. That is a wagon mount case related to bunkering operation. Okay, wagon mount case is related to. I'm repeating again and again ताकि आपको याद हो जाए. Because यही पूछते हैं वो. Bunkering नहीं पूछेंगे, wagon mount case पूछेंगे. Okay. So in this particular case, what happened that during a bunkering operation, in Sydney Harbour, a large quantity of oil, basically it fell down. Generally, आप oil filling, refilling करते हैं. Yeah, you extract oil and fill oil. So then in that particular case, there is a possibility that the oil may fall down from there. All right. So some part of the oil, negligently, it was allowed to spill on the water basically. The ships, there were fueling of oil was taking place, and the oil got spilled off into the water from the wagon mount ship. All right. And this ship was basically under the control of the defendant, okay, as charterers. Now, what happened? This escaped oil, which was spilled over on the water, it was carried away by the wind and the tide to a wharf. Wharf बना होता है ना, sea के किनारे. You must have seen rivers के किनारे, ठीक है? Wharf, which was about 600 feet away. Now, this wharf, WHARF, all right? WHARF. You have to remember these words to remember the case. That is why I'm going slow. That is the reason. So, there was this wharf and this oil was carried away by the help of wind or tide towards this wharf, and this wharf was how much feet away? 600 feet away. It was 600 feet, away. All right. Now, what happened? Okay, and this wharf was basically owned by the respondent or the plaintiff. Okay, where there was another ship which was being repaired. So what happened is soon after, the oil had spreaded itself completely. The wagon mount, obviously, the bunkering operation was over, and the wagon mount had left into the sea shore. So what happened? About 60 hours, about 60 hours later, there was this molten metal because a ship repairing was going on this wharf. Okay, यहाँ पे ship repairing का काम चल रहा था. So almost about 60 hours later, some molten metals, it fell on those oil, all right, which was already in the water. It was on what? It was on some jute materials and cotton materials. It was already in that water, and it caused a spark and fire, and it led to the destruction of the property. Clear? फिर से बताऊं facts. फिर से बताऊं facts. ठीक है? So there was this bunkering operation going on. During the bunkering operation, some of the oil fell, all right, it spilled off outside on the water. ठीक है, फिर उसके बाद क्या हुआ कि with the help of the tide and the wind, these oil, it was like taken away to some 600 feet away where there was a wharf. Already there was a ship repairing work going on. Now, when after the bunkering was done, so this wagon-bound ship, it already left itself, it left the harbor and it went into the sea because the work was done. And then, where this work, ship repairing work was going on, so the molten metal from the repair work, it fell on the debris of where the oil was collected in the water and it caused fire and led to huge damage and destruction of the wharf. ठीक है? Now what happened in this particular case? तो अगर हम re-polymerase के हिसाब से जाएं, if we go according to re-polymerase, so what do you think? What will be the result? What will be the result if we follow re-polymerase case over here? So if we follow re-polymerase case over here, then the defendant would be made liable for all the direct consequences because more or less similar facts. Okay, more or less similar facts. But can you actually say that all the time that when this happened, when this oil spill off happened on the water, so it was in the foresight, reasonable foresight of the defendant that they were aware of this fact that the winds and tides will carry away this oil like 600 feet away and there will be a wharf and the ship repairing work would be done and वहां से जो है the molten material will fall on the debris and the oil will be there and it will catch fire and the wharf will get destroyed. Can you say that this much of foreseeability would have been there? Is it possible? Right? Actually, it's not possible. So the Privy Council in this, because what happened in this case, the trial court and the Supreme Court basically, they applied the re-polymerase rule and they made the defendant liable in this particular case. But then when the matter came in the Supreme Court, so the Supreme Court in this particular case said that, it laid down two principles. And what were those two principles? That number one, the only test applicable was foreseeability of the damage, alright? And the respondent could not be held liable for unforeseeable damage. Alright, I'll just write it down for you. So what were the two principles which were laid down? Hope you have written down the name of this case and this off. So the two principles which were laid down in this case are So what were the two principles which were laid down in wagon-bound case? Number one, the only test which is applicable was foreseeability of the damage. Complaint of, you can add to it. Alright, the foreseeability of damage. And number two, the respondents could not be held liable for unforeseen damage. Alright, what was there in this case? That was the damage by fire. Alright, so the lordships in this particular case, they said that the polymerase rule is no more a good law. It is no more a good law. We have to consider this thing, that what we are expecting from an individual. So that is why this statement is very famously used in wagon mountain case, that after an incident has occurred, even a fool is wise. So you can say, हाँ ये भी था, ये भी था, ये भी था. These are the consequences which has happened, and the person can be made responsible for all the direct consequences of the act. So after an incident has occurred, even a fool is wise. But it is not the hindsight of the fool, but it is the foresight of a reasonable man that is required to evaluate a situation. So this is a statement which is very commonly asked in your exams, and then it is asked that it is related to which case. That after a consequence has happened, it's very easy to attribute that the liability on somebody else, but it is not about that. It is about that whether that consequence was actually in the foreseeability of the person or not. Only when it is in the foreseeability of the person or the reasonable foresight of the person, or there is a probability that a consequence can happen, that is why then only you can say that the liability arises. So a person cannot be made liable for the remote consequences if something is not foreseeable, reasonably foreseeable. Hello everyone, welcome back. So there was this short interruption in between. It's really lovely to read your comments because I cannot do it often when I'm focusing over here in the camera. So I'll just take a sneak peek into it. Anyway, so you understood, right? The difference between Remoteness and the Smith versus London Southwestern Railway Company case and the Wagon Mount case. Alright, and thank you so much, all of you again, for the patience. Let's get back to work. So, we know that in Wagon Mount case, the test of reasonable foreseeability was applied, and in the case of Smith versus London Southwestern Railway Company case and the case of Repolymus case. All right, we had this test of directness. So for the preliminary point of view, I think this is more than enough. Just note down for your reference. There is this one more case which they might ask you. I wanted to provide you a name, which is famously known as eggshell skull case. That is Smith versus Leach, Brain and Company. All right, please write it down. I'll just raise this. Hope you have written this. I'm just erasing it. Smith versus Leach, Brain and Company. And I also have to give you one more name. I'll give it later. Smith versus Leach, Brain and Company in 1962 का case है. Why this case is important? This case is famously known as eggshell skull case. All right. In this case, I just take ये दिख रहा है आपको? Smith versus Leach, Brain and Company, that is eggshell skull case. Alright. Now, in this particular case, it was laid down that a tort feeser takes his victim as he finds him. So, a tort feeser takes his victim, I'll just write it down. In this particular case, in Smith case, it was laid down a tort feeser, because generally they provide this statement and ask you a question. And I'll explain it to you what it is. Takes his victim as he finds him. Alright. A tort feeser, दिख रहा है ना? A tort feeser takes his victim as he finds him. Alright? Now what does that mean? Generally, I'll make it very simple. Generally, people take this defense that a person would not have got injured or harmed or hurt by my conduct if the person was not that sensitive. We are in this habit of, let's relate it to the normal life, right? We are in this habit of saying, oh, that person is very sensitive, that is why that person got hurt. Oh, that person is very emotional, so that is why he or she cried. Oh, no, that person is weak at heart, so that is why the heart attack occurred. All right, and all these things, we are in a general habit of saying all these things, but then without getting into much of detail of it, because then it will become a social issue, we are not here to discuss that. So generally, in a tortious liability case, a defendant takes a defense that this particular consequence would not have occurred if the person was not of a particular attribute, or if the person was not some sensitive, if the person did not have a weak skull, or if the person did not have a weak heart. All right. So in this particular case, but this defense is actually not very much acceptable, because in this particular case, it was held that a tortfeasor is supposed to take his victim or take the victim as he finds him. So it does not matter that whether the person has a earlier history or medical history, or whether the person has a weak skull, or whether the person is suffering with any disease or not, or whether the person has a weak heart. But if at all your conduct has caused some harm or injury to the person, then in that particular case, the liability arises. So this is what was laid down in this case, right? Now, if you're interested, you can just read the case in detail on your own. It's a very interesting case. So if you want, you can read it. I just want to finish the topic, so I'll rush a bit, right? Otherwise, again, negligence reh jayega. I have to do defenses with you, and if time permits, recips are locative. So let's see. Alright, chale, आगे चले? ठीक है. Now I have a question to you. That in case of the consequences, which arise. So can we always say, like this is related to, you can say, your reasonable foresight ka case. So there is another case which I want to give you a name. Can we say that the person's liability is only related to the exact, nature of the act? Or we can say that even if the consequences are similar to what was foreseen or what was probable, then even if there is a variation in some degree, still the liability arises. Understood my question, what I am asking? Are you able to understand my question? I repeat my question. Suppose there is a situation where the consequences which has been caused, those consequences are similar, which was foreseen, reasonably foreseen, but they are not same in the degree or same in the extent or the expanse in which they are caused. Alright? आप समझ रहे हैं? For example, burn has happened, but it will happen in such a large amount or such a large degree, it was not foreseen. Right? You understand? But you can take it as an example. For example, injury has been caused or damage to property has been caused, but it will happen in such a larger extent, it was not foreseen. But the injury is of a similar kind which can be foreseen or reasonably foreseen. So do we think that the liability arises over there or the liability does not arise over there? Exactly, all right. So there's this case of you versus Lord Advocate. Just write down the name of the case. They might ask you versus Lord Advocate. I'll just write. Hope you have written it down. And this is a case of 1963. Alright, and in this particular case, as a principle, this case is a very good illustration of a situation where the test of foreseeability or probability is satisfied or met with all the criterion, where the damage that is caused is though similar in nature, but there is a variability in the degree. Because it's not possible even for a reasonable man or for a plaintiff for that matter to take, utmost care or precaution about oneself, and even for the defendant to, reasonably foresee each and every situation. So there can be situations where there is some variations or some, differences in the degree, but yes, the injury should be similar in nature. So if the injury has to be something else, but it led to destruction of the property, then that is not an injury of similar nature. That is what you have to understand. So you can read this case as well if you want to. Alright. Now let's move to our second last but one, whatever you want to say. Because people might have different opinion. So let's talk about, what are the defenses of negligence? So quickly, people, what are the defenses of negligence? What do you think? What are the defenses of negligence? Anybody? So there are 4 or 5 defenses of negligence, right? Right, negligence का अगर tortious liability है, so there must be some defenses as well, right? So what are those defenses? एक मैं आपको already बता चुकी हूँ. I have told you already that what is one of the defenses of negligence. Number 1, contributory negligence. Are you able to see? Number 1, contributory negligence is one of the defenses of negligence. Number 2, if there is any express contract. If there is any express contract and the person has knowledge, and always remember that knowledge does not mean that, without perception, appreciation and acceptance of the fact. Okay? So it's all, don't think कि ये concept इससे अलग है. Alright? It's all interrelated in law of torts, so you have to apply your mind. Right? So express contract, then it's part of voluntary non-fit injuria only. And then I give you as a separate point, just for the purpose of you. So you can say that voluntary non-fit injuria. But then when you say voluntary non-fit injuria, again, you have to evaluate all the elements of voluntary non-fit injuria, where free consent, okay, and knowledge, not just mere knowledge, it has to be perception, appreciation, and acceptance of that particular fact. Then, what else? Act of God. Can act of God be a defense of negligence? People and inevitable accident. All right. Act of God, inevitable accident, and any other defense if you can think of. All right. So we have already understood all these things. I don't need to repeat again. It's the same for every tort. Contributory negligence, थोड़ा सा हम लोग 5 मिनट उसके बारे में बात करेंगे. Right? Yes, statutory authority. I always forget this, so you can just add यहाँ पे statutory authority. But a statutory authority, again, it's it's like a what do you say? It's a revolving point. Negligent to the extent that they can violate the rights, that is a question which needs to be discussed, and there you need to apply your mind. That can a statutory authority, that just because a person is a statutory authority has been absolved of all the responsibility, that he gets the stamp to or the approval or the certificate to get negligent, so that a right of a citizenry can be violated, that is something which has to be thought for. So that is why I'm not getting into the point of statutory authority, because we have to deal with the sovereign functions and non-sovereign functions and the state liability wala part when I start with liability. So इसलिए मैं ये इसे purposely I skip it, but then you people always drag me over here. So ठीक है, but statutory authority is a defense which you have to keep in mind. Now, what are these defenses? Contributory negligence, express contract, voluntary non-fit injuria, act of God, inevitable accident, and statutory authority. Now, as far as contributory negligence is concerned, we done that case of, remember, what was that case? Abhi kya hai humne? Rural transport versus Bejalam BV wala. Should I erase this? Have you written it? You wrote this? Right. So Bejalam BV wala case हमने अभी किया है. All right. So that is, I told you there only, that what is contributory negligence? So contributory negligence, is a situation where the claim of damages of the plaintiff, it can be just rejected or reduced because of the fact that the consequences which have occurred, those consequences would not have been the natural fallout of the conduct of the defendant if the plaintiff had not contributed into it. ठीक है, अगर plaintiff का wrongful act इसमें assimilate नहीं होता, if the plaintiff was not responsible for any wrongful act, then this consequence would not have followed. Okay, now here is a question for you. Which is this section under Indian Contract Act which talks about mitigating of losses? Anybody can tell me? Related to damages only? Which is this section of Indian Contract Act which talks about mitigating of losses? I'm waiting for your answer. I have to go to this side to see your answer. Anyone can help me out with this? Help me in recollecting it. Mitigating of loss. हम पढ़ते हैं Contract Act में. पता है? This you know? Alright? Absolutely. So does it apply only to contract or to quasi? These are two important and questions, very relevant questions of your preliminary. Okay, so does it apply, second question, only to contract or to quasi-contract also? The second question. Absolutely. So proud of you people. Alright, thumbs up. But then tell me the next question, the answer to the next question. Does it apply only to contract or to quasi-contract also? I repeat. How many of you are reading the Bail Act right now? Absolutely. Absolutely. All of you, Rutrikan, Simran, and others who are getting these answers right, absolutely. I cannot take everyone's name, but Murtaza, all of you, everybody is right, all right? So very good. So it applies both to contract and to quasi-contract as well. Okay? Now coming back to tort. So I just wanted to relate it to the concept of a contributory negligence, that if at all ever in the interview or in the mails, if they try to correlate, because as far as I remember, I think I told you in the initial lectures that in Bihar, if your upcoming exam is Bihar only, so in Bihar and mains, generally the contract and tort, it comes together. Alright, so they might give you a correlative question, or they might ask you that which is the concept which is close to this particular section or something like that to analyze, to just check your mind. Fine. So contributory negligence kya hai? That the particular consequence would not have been possible if you as a plaintiff would not have contributed, or your wrongful act would not have contributed to it. So Bejlam Bivi wala case, there are so many cases, people I'll try to provide you a list, but this is one of the cases which you can keep in mind. Now in contributory negligence, one thing more, whenever damages, you understand the difference between damage and damages, right? So damage is the injury and damages are the compensation, the pecuniary compensation that we seek for. So whenever these damages are being sought after, so there is this rule, the last opportunity rule, which is being applied. Right? Now, what is this last opportunity rule? So the concept of last opportunity rule is related to contributory negligence. Last opportunity rule. Now, this last opportunity rule is basically that a person, who has the last opportunity to prevent that consequence. So that person is considered to be more liable towards the consequences in law of tort. This is just one theory. This won't get into a lot of analysis into it, all right? Or don't get into the research mode of it. Just for the purpose of your exam, if they ask you what is last opportunity rule, or it is related to what? So it is related to contributory negligence. This last opportunity rule is applied when the damages are being evaluated or calculated and it is seen, right, over here that who is that party, like between the plaintiff and the defendant, because we know now by our discussion that in contributory negligence, both the plaintiff and the defendant are equally responsible. All right, or not necessarily, sorry, I used the wrong word, not equally responsible, that both of them are responsible. So the last opportunity rule is taken into consideration when it has to be seen that damages to provide हो सकता है. In a situation you might have, as a judge, you might have to provide damages, or a court as a remedy, you might have to provide it to them. But the point is that who is at more fault? All right. So to determine this, this is the rule which is brought into application generally. So there's this very famous case of, just write it down. Davis versus Mann. कभी कभार पूछ लेते हैं. They might ask you. Davis is related to last opportunity rule, or even they can ask you contributory negligence. Now, what happened in this case? I'll quickly tell you. I need to take permission from you. Like, if I'm not able to complete, so can I just extend the class by 10-15 minutes? Can you people stay? If you don't have any other engagements. So you can be patient, right? So that I just can finish this topic. I don't want to carry it forward for tomorrow. All right. So last opportunity rule में there is this case of Davis versus Mann. Now what is that case? In that particular case, there was this donkey. Donkey's feet was fettered. So if you can Davis, D for Davis, D for donkey. If you can just remember, essay. Can you see this? All right. So the donkey's feet was fettered, in the sense, bandhe hue the. They were tied, and he was left on the highway. So that that whenever the pet animals, they are left on the roads, generally their feet are tied so that they don't go a far off distance. So it is done for that purpose. And there was this vehicle, the defendant, he was driving that car, he just saw the donkey, so and then there was this crash which happened, and which that donkey suffered injuries. All right. So in this particular case, when the compensation was being evaluated, so the court decided upon this question that who had the last opportunity to prevent the accident, because donkey ke to pav bande hue the, his feet were fettered. So who was basically on the driving seat and driving the car? All right. So it was observed in this particular case and held then subsequently that it was the driver on the driving seat who was basically driving the car. So he had the last opportunity to prevent the accident. That is why he is more to blame too, as far as this tortious liability is concerned. So it's just a theory. Don't go into much of a detail of it. Just for your knowledge sake, I have given you this. All right. But then, later on, this theory was quite opposed. And then in there was this amendment, and I don't want to get into the detail of it. Okay, and then they came up with another theory, which is the theory of apportionment. All right. So after this last opportunity rule, I'm just raising this off. There's this theory of apportionment or apportioned. Apportioned is the word. Whatever you want to write now, just remember this theory. Apportioned or apportionment. All right. So what is this theory, as it's very clear from the name itself, that it is not about that who had the last opportunity to prevent the damage or the injury, but rather, it has to be seen that who is more at fault. All right, and on the basis of it, it has to be apportioned. The fault, has to be decided, and the liability has to be evaluated, and the damages has to be provided. So if they are equally at fault, then then the plaintiff's damages or compensation will be cut at half. So this is how they decided in this particular case, and this position is also followed in India as far as the Tortious Liability Act is tortious liability is concerned. Fine. All right. Take it. Okay. So the last topic for today is, what is res ipsa loquitur, people? Fast. I'll try to make it fast. What is res ipsa loquitur? हालांकि इसमें बहुत सारे cases हैं. Let me see. It would be too much for you, I think. Just let me start with the topic. What is res ipsa loquitur? What is it? Anybody? Loquitur or loquitur, however you want to pronounce it. Some people pronounce it as loquitur, some people pronounce it loquitur. Before you get into such discussions. So, what is res ipsa loquitur or loquitur? बताइए. Exactly. So the facts speak for themselves. Don't worry, I'll just start this topic. I will not hurry because I know this is an important topic. So I have to do cases with you, and then tomorrow I'll try to continue it. So res ipsa loquitur means the facts speak for itself. Facts speak for itself. Alright? Why is it necessary? Why is it necessary? It's very simple. It's necessary because if you see any civil proceeding for that matter, it involves facts. Alright? That is what your Indian Evidence Act is about. What is Indian Evidence Act? Proving, disproving, proving the facts. Alright? So what are these facts? These facts only make the issues. Alright, now I'll not get into a detail of it. So just to make you understand that in any civil proceeding, or for that matter, any proceeding, alright, there are certain facts which are required to be proved. Alright, so that is why there is a concept of burden of proof. And on whom the burden of proof lies. Alright, which party has the burden to prove a particular fact so that the court can provide justice to that party the way in which the party desires. Alright, so that is why you have this whole lot of section of 101 to 111 in your Indian Evidence Act, which talks about burden of proof. That in any civil proceeding for that matter, you have to prove certain facts, and the party has a responsibility, a duty, or a burden to prove certain facts, and that is why it's based on those sections we can come to the conclusion that which party has the burden to prove a particular fact. Now, what does section 101 says? Right? Or for that matter, if you read 102, 102 is a shifting burden of proof. I'm not getting into that because this is not an evidence class. But what does section 101 says? It says that if you're alleging a fact, so you have to prove that fact. As simple as that. If I am saying that this is a fact which has happened, so it's whose responsibility to prove that fact? It is my responsibility to prove that fact. So the burden lies on me. But what if in a situation Alright? The facts speak for themselves. You understand? Alright? So when a plaintiff alleges a fact that this is a situation which has happened, no, these are the consequences which has occurred. Alright? Then whose responsibility it is to prove that fact? The burden lies upon the initial burden of proof lies upon the plaintiff, right? Who has the initial burden of proof? The plaintiff. You have done in your criminal law as well. Who has the initial burden of proof? The prosecution, all right? So when I am alleging as a plaintiff, if I am a plaintiff and I am saying that this is the consequence which has happened, so the initial burden of proof lies upon me. But there can be certain exceptions to it. Now, what are those exceptions? The one exception is that when the facts speak for themselves. So that is why we say that section 106 of your Indian Evidence Act is an exception to section 101. Right? So when the facts speak for themselves, they are so clear. There is no two theory possible or no two stories possible. All right? Then the initial burden of proof shifts from the plaintiff to the defendant. And then it is the responsibility of the defendant now to disprove the fact that is alleged by the plaintiff. Clear? Clear or not? Clear, everybody? Yahan tak? Hope it's not much complex for you. I'm more concerned about the people who are first time reading it. So, people who are well read, they must be knowing what I'm talking about. Right? So for them, it is just like a revision. But people who are first time, trying out for the exams, so you understood what is burden of proof? So whenever there is a proceeding which is going on, you have to prove certain facts, right? And किसके ऊपर the initial burden of proof पहले किसको prove करना पड़ता है? भाई जो fact allege कर रहा है वो prove करेगा, ठीक है? Only that party will prove it, alright? So when there is this plaintiff who alleges a fact, so plaintiff needs to prove the burden lies on the plaintiff. But when the fact is clear itself, कि और कोई तरीका, there could not have been any way out, except one, that if the defendant would not have acted in a particular way, this consequence could not occur. Then the facts speak for themselves and the initial burden. Remember people, it's not that the initial burden of proof lies on the defendant. The proper word is the initial burden of proof, which is there. It shifts from the plaintiff to the defendant, and then the defendant has to now disprove the fact. So that is why it is said about res ipsa loquitur that this is not a rule of law but a rule of evidence. All right, but the facts have to be very clear, and it should not be such which suggests two theories or two interpretations. Then only we can say that the facts speak for themselves. Clear? Clear, all of you? Okay. Fine. So I'll not get into the cases today. There are so many cases like Mahendranath Mukherjee case. That is why I did not discuss it that day. Then there is clock tower case. Yes, one of the example of this case is the clock tower case. All right, which you can take into consideration. As far as res ipsa loquitur is concerned, then there is Bryan versus Bodel case. It's a very interesting case. I personally like that case. So we will be doing this case. I'll just take 10 minutes tomorrow, 10 or 15 minutes tomorrow to finish the cases of res ipsa loquitur. And then we can move further. I'll be starting with some topic which I'll see what topic I want to start with. Right? Fine. So thank you so much. Thank you for your patient listening. So in case if you have any doubt or queries, yeah, you can send me your queries on this mail ID, Sonia@RostrumLegal.com. rostrumlegal.com. Alright, I'm not able to take up your questions and queries and discussions because I cannot afford to do that over here. There are so many vibrant minds, and I know there must be some questions also. So please, send me your queries, whatever doubts you have, try to keep it genuine, please, which are actually relevant, and send them over here, and I'll definitely try to get back to you. Alright, so this is the email ID, sonia@rostrumlegal.com. You can just reach me over here and just send me your queries or questions, whatever you have. Fine. So thank you so much. Let's connect tomorrow and then we can see what we can do further. All right. God bless.